last week, my lord. This is regarding a teacher, primary teacher, who suffered a termination, my lords. And she travels to this court, my lord, on the premises that she wasn't given any opportunity of hearing, my lords. And she being a confirmed employee, the procedure was not properly followed, my lord. Now, the respondents, there was a notice.
Why it was adjourned for?
It was adjourned because I sought for time, principally a week's time. The reason was, my lord, why I took time, let me be very frank with my lords, because we were wanting the bylaws of the organization. Now, they're out of bounds. They are anybody going to them out of bounds, the respondent is concerned. They did not at all cooperate. Now, why I said this, my lord, is because now it is not a state within, they did not file the reply. They just make an IA, my lords, a preliminary objection that being a minority institution, a private minority institution, is not within the ambit of Article 12 of the Constitution. Resultantly, the petition is not tenable, my lords. The learned single judge was kind enough to peruse the decision in St. Mary's case and said on the substratum of the decision, my lord, dismiss the petition, my lords. My submission to my lords would be like this, my lords. Now, if we have a perusal, the basis of the decision is St. Mary's only, my lords, because the facts did not come before the court. The one submission which was not before the learned single judge was in regard to a non-government institutions who are private. They are covered by the 1975, my lord, the Adhiniyam. Now, 1979 Adhiniyam postulates certain statutory obligations on the institution, my lords. Now, all this was not done because insofar as tenure of employment is concerned, 9 makes it very, very clear that there has to be a protection as far as tenure is concerned, a procedure to be followed, my lords. Now, this was very much there, though it was not spelled out before the learned single judge, number one. Number two, and we do not find place in the order also. Now, before I come to the order of the learned single judge, may I draw my lord's attention to St. Mary's education. I'm making twofold submission at the outset. Now, that is number one, my lords. It was essential for the respondents to have submitted at least their return, stating those facts as to how they say it doesn't fall within the ambit of Article 12 of the Constitution, my lords, their bylaws, etc. Nothing was on record for analyzation or for discussion by the learned single judge, my lords. There was no such document or a detail stating the factual matrix was also not available to the learned single judge. Now, if I can take, my lords, on the last date, my lord, I had, my lords have the copy of St. Mary's, my lords. Just permit me, my lord, because I know what the court has, the twofold would be now. If I can just take, my lords, to para 15, which comes the legal status. Even the Supreme Court dwelled with the bylaws and then finally it comes to a conclusion. This is what I'm trying to say. Here the respondents did not file anything at all. Now, if my lord has a perusal at para 15, my lords, we did make an endeavor to get the bylaws, my lord, but we were unsuccessful. It says the appellant number 1 is a society registered under the Madhya Pradesh Societies Registry in Adhiniyam 73, so and so, and finally school is presently affiliated Central Board of so and is thus governed by the rules and the bylaws. Right, my lords? Now, I skip all that and come to para 40, 49. Right, my lords? Which comes at page 22. I'm only trying to demonstrate that Supreme Court even discussed all these components, my lords. 49 says, in the case on hand, the facts are similar to Rule 26(1) of the affiliation bylaws framed by the CBSE, provides that each school affiliated with the board shall frame the service rules. So and so provides that a service contract will be entered with each employee and what they are supposed to do, my lords. Insofar as the affiliation bylaws are concerned, right, my lords?
Yes.
Now, when we have a perusal, my lord, again 50 speaks about the affiliation of the bylaws, and when we come to 57, all the case laws was, they were scanned. Now, the scanning takes place further 57, that comes at page 25. Right, my lords?
Yes.
We may say without any hesitation, respondent number 1 herein cannot press into service the dictum of law laid down by this court in the case of Marwari Balika Vidyalaya, so and so, as I said, case is distinguishable. The most important distinguishing feature of the case of so and so is that in that case, the removal of the teacher was from service subject to approval of the state government. There was a provision in that regard, right? Now, 58. In context with Marwari Balika so-and-so, we remind ourselves of the bylaw number 49 too. I mean, the court scanned all these things, my lords, which provides that no order with regard to the imposition of a major penalty shall be made by disciplinary authority except after the receipt of the approval of the disciplinary committee. Now, we come to 50. So therefore, my lord, now we come to 68. And on the basis of whatever it was, my lord, the conclusions have been drawn. Now, we have filed, my lord, the 1975 Adhiniyam. If my lord has a perusal, which comes, my lord, at page 40, it starts, my lord, from 44, A5, my lords. Now, these are the Madhya Pradesh Ashaskia School Vinayam Adhiniyam, my lords, 1975, my lords. Now, if I can just take, my lords, the school is, of course, means Ashaskia, primary, middle, secondary, which is at page 45, my lords, the definition clause. School means an Ashaskia, primary, middle, secondary, technical, secondary school and includes training institute up to the second, and any other institution which imparts education or training. Now, when we have a perusal, my lord, at page 48, are the terms and conditions of service of the employees. 9, my lords, terms and conditions service of the employees. The state government may make rules regulating the minimum qualification for so-and-so, so-and-so, and 9.2 says, no existing employee or employee of a recognized school shall be dismissed, removed, or reduced in rank, nor shall his service be otherwise term is saved in accordance with the rules made in that behalf. So all those things, though it was not spelled out before the learned single, because I don't see anywhere, neither in my petition I see, my lords, and neither in the order. So these were the statutory rules, my lord, whether they have those, nothing has been spelled out by them, my lords. So what a prejudice has been cast to me, my lords.
Yeah.
My right to livelihood had taken away on the basis of St. Mary's decision, my lords.
Yeah.
So I pray to my lords, at least they can file their reply here, or it can be, my lord, before the learned single judge, my lords.
For the Supreme Court, it is not facts of that law which was formulated.
Very right.
So the law that is in para 3.
Whether discharge the duty, right. It's a public function,
So
very
the
right.
answer is in
69, but
suppose the Honorable Supreme Court take into the bylaw, take into the provisions that govern service conditions and then determine, then it is fine. That is not what they say. That incidentally they got into the rules and bylaws. It's a different matter. But their answer is not dependent on that.
no, the answer is not, but it goes on to bring it out, man. That's how the filtration takes place of the, with due respect, the facts get filtered. Now here the facts were not before the learned single judge at all.
No, that's what we are saying. Facts are of no relevance because it's a question of law raised by the Supreme Court. This is a question of law, and that is the answer.
My lord, but
this
after,
is not a determination on facts.
I get that. But how the learned, my lord, the Supreme Court, my lords, after looking into n number of cases that have been propounded by the apex court, my lords, in fact, these were certain factual matrix which were looked into, my lords.
So they may have looked into it, but what is the answer to that?
And then coming to a conclusion.
Is that conclusion dependent on facts?
I mean, that is how it has been dealt with. Can I please? That is how it is. And that is how the filtering of the case laws have taken place in this decision.
If the answer is based on a contingency,
Right.
being the rules, laws, or bylaws, then
Right.
it is all right. Suppose the Honorable Supreme Court says, no, it's not maintainable. But you can arrive at the conclusion after looking into the relationship between these two. Then it is fine.
Right.
That's not what they say. It's very clear. The question is whether it's maintainable against private unaided minority. Answer is no. That's all. How they go, how they arrive at it is not factual.
I get that, my lords. But para 15, my lords, start with that, the legal
Suppose that was
status.
your argument, then it is correct. Then we understand. Then we have to go into the relationship between you and them. What the bylaw says, what
Right.
the statutory process.
This
Then
is
we
what
have
I'm
certainly
trying-
done that. The
this is-
Supreme Court has said so.
Right.
They have not said so. We are looking at it like that. It's a,
My only,
you got to come from page 3 directly to page 32. The rest of it is
yeah, I get that, my lords. I get that, but with due respect, my lords, frankly speaking, otherwise all these things would not have taken place.
Yeah.
All these distinctions wouldn't have taken place.
necessary to keep issuing notices in every case. the judge feels there is nothing
I
to
get
be
that.
done, a petition should go. Why we should hear them to have no doubt on facts on law?
It says in view of the aforesaid discussion. Right, Alex? Para 69. In view of the aforesaid discussion, we hold
So what they hold?
that the learned single judge of the High Court was justified in taking the view that the original petition. Right. So in view of the aforesaid discussions that have taken, can that be ignored? Can we ignore or what?
That's not our facts.
Well, in any case, my lord,
Some of the
with due
earlier
respect,
judgments say that in order to determine the petition or 226,
I get that.
a factual matter has to be gone into.
Right.
Whether you are doing public functions are involved.
Very right.
This.
Right.
That's not what they say. Suppose they say so, it is fine. Then it is not a new law, it's an old law. There seems to be some deviation in this St. Mary's.
my only prayer to my lord, at least there have been, we file another document, my lord, order of this learned single judge. Preliminary objections on that basis, my lord, the petition should not be dismissed, my lord. At least they should come up with a reply, my lords.
Why replies are required?
Right.
Some capacity
My lord,
to dismiss it on day 1 or 2.
My lord, 69 caters for 68, my lords. Am I correct on that?
Go back there and tell them that this is how
My lord,
reading it.
my lord, 69, had this words were not there, aforesaid discussion, my lord.
You go ask them, what do you mean by that?
My lord, no, my lord, I know my lords have been gracious enough. No, my lord, my only prayer to my lords would be, in view of the aforesaid discussion, meaning para 68. And in 60, my lord, 68, my lord, they pen down the whole thing, my lords, which is already there earlier. It has to be in continuity, my lord, with due respect, it has to be read in continuity. Can't be in isolation, my lords. This is what it said, in view of the aforesaid discussion. Now, where is the discussion? Discussion is in para 68, A, B, C, D. And when we look into that, we may sum up our final conclusion as under. These are the words. Well,
Use that in all judgments.
No, only thing, I have been deprived of all the cooperation which the association could have given us in the court of law.
No, we understand.
But may I make a very humble prayer? If at least reply could be taken, my lords, and then my lord,
we don't need to.
Because if it covers,
you have to convince us. So you please get some clarification by the Honorable Supreme Court what they mean by this.
No, it's very clear. With due respect, my lords, very clear, my lords.
No, it is clear to you. It is clear to us also.
Then, my lords,
but we are clearly looking at two different things.
My lord, can it be? Can I make a very humble prayer, my lords? At least if the respondents come up with their reply, my lords.
It's not going to change.
It might change, my lords. If the bylaws makes it something different, my lords.
We have no doubt about it. We are not getting into the bylaws because of what the Honorable Supreme Court said. We read it like this.
Well, my respect.
I don't think it is very taxing to.
No, it's not taxing. No, it's very clear.
It's so clear that this is a question raised.
Therefore,
this is the answer.
Therefore, the clarity is the answer comes in. 69 goes to 68. 68 brings it out elaborately how they've come to a conclusion, and then 69 gives the entire thing. Now, my only submission before my lords would be A. 69 cannot be read in isolation to what has been spelled out in 68. And in 68, very clearly, it brings out everything. And that is because of what has been dilated upon by the apex court in the earlier paras. And my humble submission is the bylaws, because they said its affiliation with the CBSE, resultantly, they are a state in the meaning of so and so. That is how it was spelled out. That is how the scanning took place by the apex court as far as the present case was concerned. And that is how it is, my lord. Now, again, my lord, I'll make my whole endeavor.
Possible itself is sufficient for us not to. Sense of clarity, based on your understanding and our understanding. Certainly, we don't want to get into an exercise and presume that this is what the apex court intended and this is what it said. We don't want to get into it.
Well, this will be last limb, my lords. In para 68, my lord C. This comes at page 31. Right, lords? It must be consequently held that while a body may be discharging a public function or performing a public duty, and thus its actions becoming amenable to judicial review by a constitutional court, its employees would not have the right to invoke the powers of the High Court conferred by Article 226 in respect of matters relating to service where they are not governed or controlled by the statutory provisions. Here we have the 1975 Adhiniyam. This is what I'm trying to bring out to my lords, and a protection of tenure. So there is a statutory provision, my lords. Now I leave it to my lords.
You see, para 4, how they have dealt with the judgment, with what intent the apex court considers it. Para 4 of their order. The aforesaid two questions, though not vexed, that means it is not at all an issue. Nevertheless,
Yes,
despite a plethora of case laws,
yes.
always gives rise to a debate.
But then factual matrix comes in. But the factual matrix comes in thereafter. Otherwise, it should have been stopped there with due respect.
To say it's an age-old question that has been answered.
Right.
But every time it's being argued. That's what it is.
No.
They start the judgment like that.
My lords, there are n number of decisions this way or that way, my lords. But insofar as if that was so, my lord, the learned, I mean, the above before this court, as also the apex court, goes on to dilate on the facts of the matter, my lords. It's not a straightaway coming to a conclusion like that. And this is my only submission, my lord. Supreme Court has something before them, whereas here there was nothing. Now I leave it to my lords.
So the argument, single page, you give scope for new argument.
My lord, may I make a very humble prayer? Well, I only make it in the order, my lord. If it could come that 1975 statutory provisions are applicable to the non-governmental institution, if this could come.
I think we are not.
Well, please, my lord, because I may have a problem later.
We are not going to create new litigation.
No, I may have a problem later, my lords, with due respect. If this could come in that, because this is, we have filed also. This is the ground, my lord, in the appeal.
The rejects it purely on
the decision.
maintainability only.
Right.
So we will only answer on maintainability.
Well, therefore, I'm trying to say, because maintainability only we say that in the light of this decision, we have said so in our memo of appeal itself. Very clearly, we said so. My lord, this comes at para B at page 10. I only make a very humble prayer this should come in the order, please, because the respondent institution has been duly recognized as such. The Madhya Pradesh Shaskya School Adhiniyam 1975, enforced on 27/10/75, provides regulation of Shaskya schools in the state of Madhya Pradesh and for the better organization, development, and matters connected therewith or incidental thereto. Insofar as the expression school is concerned, it has come to be defined under 2G of the Act and has in the ambit a Shaskya primary school also. The Act further provides that the provisions contained in Section 8 of the Act that not only a recognized school, but also schools which are awaiting for recognition would be bound by the duties and the responsibilities envisaged under Section 9234 of the said Act. In other words, the implications arising under Section 92 of the Act is concerned, it provides a statutory protection to an employee of a recognized school. In other words, a teacher appointed in a recognized school has come to be provided security of tenure and protection. And the doc. So my only prayer this could come in the order. This is my submission.
It is not even touched upon.
Well, because this was never spelled out with you. I think so it was never spelled out also.
Was this ground available in the writ petition?
No, it was not there.
Was there?
Well, this is a legal, my lord. This is a legal, my lord. This is a legal submission. I can always take that, my lords, in the light of the decision of in St. Mary's, my lords. So then I may have to file a review. Please, I make a very humble prayer if it can come in, my lords. Please.
We don't know what you have to do.
Wait, you apply to